welcome to our documentary on Burwell versus Hobby Lobby, a landmark case decided by the Supreme Court in 2014. Today we are going to provide an overview of this case, including its background, legal arguments, and the Supreme Court's decisions.
This case revolves around Hobby Lobby, a chain of arts and crafts stores that objected to the contraceptive mandate in the Affordable Care Act, arguing that it violated the owner's religious beliefs.
This case eventually made its way to the Supreme Court, where they ruled in favor of Hobby Lobby, allowing religious corporations to be exempt from the ACA's contraception mandate. The court ruled that the mandate substantially burdened the exercise of religion and that the government failed to show that it was the least restrictive means of achieving its compelling interest.
To begin, let's delve into the facts of the case. As mentioned in the introduction, the passage of the Patient Protection and Affordable Care Act by the Obama administration included a mandate for any employment-based group healthcare plan to provide certain types of preventative care, like FDA-approved contraceptives. Exemptions of this mandate were made available to religious employers and nonprofit religious institutions. However, no exemptions were made available to private for-profit entities like Hobby Lobby. Therefore, the Greens, the family owning and operating Hobby Lobby, sued the then Secretary of the Department of Health and Human Services, Kathleen Sebelius, back in 2012, arguing that the contraceptive mandate violated the Free Exercise Clause of the First Amendment and the Religious Freedom Restoration Act of 1993, the RFRA. Prior to making its way to the Supreme Court, the case was first heard by the District Court, which they then denied the plaintiff's preliminary injunction to prevent the enforcement of tax penalties. A two-judge panel of the U.S. Court of Appeals for the 10th Circuit affirmed this denial by the District Court. The Supreme Court also denied the tax relief that the plaintiffs were seeking. Finally, the plaintiffs filed for an en banc hearing, which was then reserved by the en banc panel Court of Appeals, who reversed the decisions previously held and then held that corporations were persons and an extension of the owner's beliefs, and therefore they had protected rights. The majority court opinion held that Congress enacted the RFRA back in 1993 in order to provide very broad protection for religious liberty, and that under the Act, persons are entitled to an exemption from the rule unless the government can provide demonstration that the burden furthers a compelling government interest and that the burden is done in the least restrictive means to further that compelling interest. Sylvia Matthews Burwell, the Secretary of HHS, represented the government during the en banc hearing.
Now for the legal arguments. Are for-profit corporations exempt from the contraceptive mandate due to the company owner's religious beliefs? To address this, we break down the arguments into three main questions. The first one, are corporations people under the RFRA? According to Burwell, the RFRA does not exempt corporations from complying with federal law. The regulation applies to the corporations, not the individual owners. How does a corporation have religious freedom?
Well, are corporations people? Yes, because Paul D. Clement says, and they rely on the 1871 Dictionary Act to provide the definition of what is considered a person. In the Act, they say that a person includes both natural persons like you and I, and companies like Hobby Lobby. Therefore, the RFRA should apply to Hobby Lobby. Which brings us to our next question. If the RFRA applies, is there a substantial burden on the free exercise?
Okay. Well, the RFRA doesn't apply, but if it did, there is no substantial burden because women receive contraceptives through a group health plan, not the companies themselves.
Well, yes, there is a clear substantial burden because Hobby Lobby, if it does not comply with the mandate, will be forced to pay millions of dollars in fines, and will also have to fight this battle in court. Clear draconian measures as set by Clement and Hobby Lobby.
Okay, but is the mandate the least restrictive means possible? It is the least restrictive means possible. The government has, quote, compelling interests in public health and gender equality, as stated by our brief by Burwell. Administering it through health insurance is the least restrictive means possible to carry out the government's goals.
No, it is not the least restrictive means possible because the government has already given out exceptions to the RFRA to nonprofit corporations and other religious bodies. If it can do that for other people, it can do the same for Hobby Lobby. Not only that, but the government can also further its interest by paying for the contraceptives itself. That is the least restrictive means possible. Even then, Clement argues that the compelling interest in public health and gender equality is much too vague for the RFRA.
The court found it important to address this case for a number of reasons, and we can see why when we look at the agenda setting process. First, we know that Sylvia Burwell, the secretary after Kathleen Sebelius, petitioned for a writ of certiorari after the 10th Circuit decision against the government. However, the 10th Circuit did rule in conflict with the 3rd Circuit on a similar case, Conestoga Wood Specialties Corporation. And according to Baum, it's conflict among lower courts that is often a critical factor in agenda setting. And that was definitely the case here. Second, the importance of the issues in the case was also pretty relevant. Baum emphasizes constitutional issues and federal statutes as primary issues for the court. And this case had both. First Amendment concerns and the statute of RFRA were both prominent aspects in the legal arguments. Third, the justice's policy preferences also appear to have influenced the court's decision to hear the case. Baum explains that justices may vote to hear a case if it can result in favorable policy. And one New York Times article by Adam Liptak gathered that these conservative justices, such as John Roberts, Justice Alito, etc., appeared receptive to arguments of religious freedom during oral arguments. And lastly, the identities of the participants, or the advocates, were also important, as Baum mentions. Don Verrilli was the contemporary Solicitor General arguing for the government, and Paul Clement was a former Solicitor General in the Supreme Court specialized private practice, representing Hobby Lobby. Both of these guys were big repeat players with strong reputations and the respect of the court. Baum regards those positions as very successful in winning petitions for cert, and later for evaluating their arguments.
The petitioner and the respondent were not the only actors arguing. Several third parties lobbied the court in the form of amicus briefs. As early as the decision to grant cert, 6 briefs encouraged the court to hear the case. For the merits of the case, over 50 supported the respondent, while just over 20 supported the petitioner. The amici supporting Hobby Lobby included a diverse group of religious organizations, conservative legal groups, and business interests, such as the Southern Baptist Convention, the Beckett Fund for Religious Liberty, and the National Federation of Independent Business. Like the respondent, many of the groups argued that the contraceptive mandate violated the Religious Freedom Restoration Act, or the RFRA, and that closely held corporations should be granted the same protections as individuals regarding religious freedoms.
The amici supporting Burwell, the petitioner, included support from universities, organizations that value the decoupling of church and state, religious organizations, predominantly Jewish ones, scholars, academics, law centers, medical centers, members of Congress, and research centers. Generally, these arguments revolved around corporations not having a right to exercise religion and being unable to claim protection under the RFRA. Further, granting religious exemptions to for-profit corporations would harm third parties like the employees who do not hold the same religious beliefs as their employers. Additionally, there is compelling interest for the government to protect access to women's health care. According to Soloway and Collins, the respondent was expected to provide more amici overall as a response to the briefs provided by petitioner in support of the government. They also note that civil rights and economic cases tend to receive more amicus briefs, which is supported by the literature from Baum.
The court ultimately ruled in favor of the respondents in Hobby Lobby. Chief Justice Roberts, Scalia, Kennedy, Thomas, and Alito all voted for Hobby Lobby. Justice Ginsburg, Breyer, Sotomayor, Kagan all voted in favor of the petitioner, Burwell. As explained in the previous section, the 10th Circuit Court of Appeals ruled that Hobby Lobby is a person who has religious freedom, so this decision was affirmed by the court and ruled the case with final judgment. The case was not sent back to the Court of Appeals. Of course, the new main policy decision is that the RFRA now included corporations in its definition of persons, and thus they should be protected by the RFRA. But this is only for closely held corporations and only applies to 4 of the 20 contraceptives that were mandated in the Affordable Care Act. The Obama administration also came up with new rules for private accommodations for a company if it met the definition of a small, privately held company as defined by the Supreme Court. The Obama administration proposed a new rule, which would go into effect immediately to address the concerns of nonprofit groups. Under the proposal, a religious college or other nonprofit group could inform the Department of Health and Human Services of its religious obligations, and the department would then contact insurance companies and arrange the birth control coverage at no cost to the employer or its employees. Afterwards, the administration did not try to fight the decision. The majority agreed that Hobby Lobby with Hobby Lobby that the RFRA does apply to corporations and that the government did show that it had compelling interests in providing healthcare to women, though they disagree that it was the least restrictive method that the government had. The decision seems to be based off the plain meaning of the law, because the respondents heavily relied on the Dictionary Act and the word persons. It seems to go against the original meaning of the RFRA, which was not supposed to erode civil rights under the guise of religious freedom. It does not seem to be based off of precedent or of the original legislators' intent.
Baum says that group interactions play a large role in making decisions. However, in our case, it seems that this was not so. With a 5-4 split, it seems that there was not much group interaction within the court, meaning that the conservatives all agreed with each other and the liberals all agreed with each other. So there wasn't much deliberation between both sides to come up with a decision.
Justice Anthony M. Kennedy wrote in his concurring opinion that the government had not met its burden to show that there was a meaningful difference between non-profit religious institutions and for-profit religious corporations under the RFRA. Because the contraceptive requirement accommodates the former while imposing a more restrictive requirement on the latter without showing proper cause, the requirement violated the RFRA.
Justice Ginsburg delivered the dissenting opinion with Justice Sotomayor joining in. Ginsburg delivered that the RFRA was not intended to apply to for-profit corporations and that the majority decision goes against what the Constitution allows because it could impose the religious beliefs of the owners onto those of the employees who may not align with the beliefs of the owners. Justice Breyer also delivered a separate dissenting opinion with Justice Kagan joining in, stating that the majority decision harms and ignores beliefs of third parties, like employees, and that there is compelling interest for the government to provide women with access to contraception. The dissenting opinions lead us to believe that the justices have a strong stance on the separation of church and state, women's reproductive rights and access to healthcare, religious freedom, and people over profit or corporations.
As for the concurrent and majority side, it seems that their policy preferences tend to favor religious freedom, business autonomy, and a firm pro-life stance.
In 2014, the Supreme Court ruled that closely held corporations with religious objections to certain forms of contraceptives mandated by the Affordable Care Act could refuse to provide their employees with health insurance that covered such forms of contraceptives based on religious objections. This decision granted corporations the right to opt out of providing contraceptive coverage based on religious beliefs. However, challenges and complications have arisen in implementation. The executive branch of the federal government, specifically the Human and Health Services, were responsible for implementing the decision by creating regulations that accommodated the religious objections of the corporations. This led to debates about how the decision applies to other types of corporations and the broader issue of religious exemptions from the government regulations. For example, in 2015, 52 nonprofit organizations opted out of Obamacare's contraceptive coverage requirement, citing religious objections. In response, the Human and Health Services created regulations that allowed closely held corporations to opt out of providing contraceptive coverage, while the Department of Labor issued new rules that expanded the ability of employers to claim religious exemptions from certain regulations. In addition, some members of Congress introduced bills that would either limit or expand the reach of the decision. For example, the Protect Women's Health from Corporate Interference Act would have limited the scope of the decision, while the Healthcare Conscious Right Act would have expanded the ability of employers to claim religious exemptions. As Baum notes, the decision fell in line with the court's broader trend of expanding religious exemptions from government regulations. However, implementation was not without challenges. This decision was successfully implemented in appellate courts, but it was not strongly enforced after the lower courts. To prevent such complications, policies were put in place to ensure that the decision was consistently enforced.
So, as we explored today, the decision proved to be an influential case. The case has potential implications for religious exemptions for federal mandates that may affect other marginalized groups, such as the LGBT community, and giving more rights to corporations. This case is a good illustration of the policymaking processes of the court because they interpreted federal statutes and limited the power of the executive branch. These factors make it clear why Burwell v. Hobby Lobby was a landmark case.
Peace. Religious objections to certain forms of
Administration included a mandate. Wait, go back.
Burning because Hobby Lobby, if it is forced, oh fuck,